Welcome to today's discussion. The topic of today's discussion is on mistake of fact is a general exception. Mistake of fact in a good defense in a criminal prosecution. Sections 76 and 79 of the Indian Penal Code deal with mistake of fact. Let's see what Section 76 of IPC provides. Section 76 of the Code provides for the act done by a person bound, or by mistake of fact believing himself bound, by law. The Code provides that nothing is an offense which is done by a person who is, or who by reason of a mistake of fact and not by reason of a mistake of law in good faith believes himself to be bound by law to do it. Let's see an illustration of Section 76. A soldier fires on a mob by the order of his superior officer, in conformity with the commands of the law. A has committed no offense. Here is another illustration. An officer of a court of justice, being ordered by that court to arrest Y, and after due inquiry, believing Z to be Y, arrests Z. A has committed no offense. It is to be noted that mistake of fact alone is excused. The maxim, ignorantia facti doth excuse it, provides for the same. Mistake of law is not an excuse. The maxim, ignorantia juris non excusat, provides for the same. The maxim means ignorance of law is not an excuse. By Section 76 of the Code, an act done by a person is not an offense if it was done by him under the following circumstances. 1. There was mistake of fact. 2. Though there was mistake of fact, he in good faith believed that he is bound by law to do it. 3. The mistake should not be of law. Now let's see what Section 79 says. Section 79 provides for the act done by a person justified, or by mistake of fact believing himself justified, by law. The Code provides, nothing is an offense which is done by any person who is justified by law, or who by reason of a mistake of fact and not by reason of a mistake of law in good faith, believes himself to be justified by law, in doing it. Let's see an illustration of Section 79. A sees Z commit what appears to A to be a murder. A, in the exercise, to the best of his judgment exerted in good faith, of the power which the law gives to all persons of apprehending murderers in the fact, seizes Z, in order to bring Z before the proper authorities. A has committed no offense, though it may turn out that Z was acting in self-defense. By Section 79 of the Code, an act done by a person is not an offense if it was done by him under the following circumstances. 1. There was mistake of fact. 2. Though there was mistake of fact, he in good faith believed that he will be justified by law for the acts done by him. 3. The mistake should not be of law. So, under Sections 76 and 79 there should be mistake of fact and not mistake of law. In both the cases the act of the accused should be in good faith. Let's see the differences between Sections 76 and 79. In order to get defense under Section 76, the accused must show that he believed in good faith that he was bound by law to do it. In order to get defense under Section 79, the accused has to show that he acted under the belief that he is justified by law and his act should be in good faith. That's all for today's video. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning. A video from Law Aspirants Hub.